Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
Bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
Yes, because the child is merely applying as a dependent of the mother.
The mother.
And the mother is the wife of the sponsoring husband in the United Kingdom. So the issue of sole responsibility
wouldn't come in.
If they are married, of course, it would be presumed, it's a presumption in law, that a married couple have parental responsibility. Both of them should have parental responsibility for their child, especially for births after 2003 in the United Kingdom.
Yes.
So sole responsibility per se shouldn't go into issue. What may go into issue in that kind of case is if that child is not the biological child of either parent, and then you're looking at the other parent of that child. So let's say the gentleman living in the United Kingdom is not the biological father of that child.
Yes.
So the biological father of that child is alive in that country. Of course, that biological father may need to provide consent for that child to go with his or her mom to come and live with the sponsoring parents in the United Kingdom. So you may have sole responsibility come in through the back door, in that kind of situation.
Okay, now in the situation also, moving away from that, in another scenario, the mother, this application has now been refused, and now another application was lodged at another time when this child has now moved from being a child to now being a son, and obviously technically saying he's now an adult, crossed over the 20 years. The same application was lodged with the mother to come and join the father, and that application was refused on the sole basis that obviously it might be from the partner's, the mother's side. The application was refused by the Home Office. Now, having come over, having appealed, the appeal was allowed on the basis that the wife, they're satisfied that the husband and the wife are in a subsisting relationship, and there's no reason why to exclude them from having to join each other. Now, the son, who is now 20 years old, having lodged the application with the mother again, the second time, now was granted on appeal. Now, the Home Office thereafter considered that that application was granted in error because they feel that that child, that son, ought to apply separately, and then circumstances taken and the requirement we mentioned here are satisfied before that son can come and meet the father. But how justiciable is that, being that he's joining the mother to come over to the United Kingdom? Would that have to be detached into two to deal with this one who is now 20 years and to deal with the mother who is clearly coming to join the father or the husband?
That's a pretty unique case because you've got two levels of decision makers having taken a decision on that application. The first level decision maker is the entry clearance officer. So if, in your scenario, if that child was already 20 years old and applied as a dependent and that wasn't picked up at that stage.
And then it was obviously wasn't picked up, it was refused.
It was
and
refused,
on appeal.
And then it goes to appeal.
And not granted.
An immigration judge still doesn't pick that up and allows the appeal. And as the decision being implemented.
The decision has been implemented. Yeah. The son now, so to say, granted a visa, but later on, the Home Office feels that this was done in error. We want to revoke it. I mean, how? Because it clearly, being that the application could have been gone
That would be
side
a
by
good
side
case
in terms of
for,
application.
it would be a good case for judicial review. Of course, when you have errors, the Home Office is not strictly bound because, I mean, if you look at it, if somebody applies for indefinite leave to remain and they receive a certificate of naturalization in the post,
yes,
that's apparently not what they have
absolutely
applied for.
yeah,
So
definitely.
you've got a significant error there. The Home Office should not be bound by that error. But there's always a scope for lawyers to go into court and argue. For instance, I might consider that the issue of estoppel arises in that kind of case. Estoppel being, if I make a representation to you, then I'm estopped in law from reneging on what I have said to you. So I might want to go into court and claim estoppel, which strictly does not apply here, I have to say.
Definitely.
But a lawyer will be best placed to
grant it.
really look at
you said
those
something about
points.
judicial review there. That's clearly where the issue comes in there, because we get quite a lot of cases where both parents applied. A parent applied to join the other husband, and that process comes together with the children, and they are now sons or daughters, having crossed over 18 years old. And that leaves the Home Office to make a decision. And is that possible that the mother will be granted and the children left behind? There's Article 8 coming there to aid them.
Absolutely. So you've got serious Article 8 issues there. So the Home Office would have to really give good reasons why the mother should be allowed to come into the United Kingdom, leaving the children behind.
The sons now.
Now, even if we're talking about sons, and those sons have made proper applications, they've applied individually to join, their parents as they should, being over the age of 18.
Yeah.
And the application is going to be refused. The Home Office has a duty to show that they've considered Article 8 of the Human Rights Convention, and that they've come to a decision that it will be proportionate to separate the family. Because that's what the decision is effectively going to do. Right,
right. Ladies and gentlemen, we've still been discussing this matter today. We have a call on the line. Lucy, where are you calling from? Hello? Okay, we lost that call again. So we before I discuss that with you, I want to address the viewers. Ladies and gentlemen, as I said, we've been discussing sole responsibility today. It has been a soul-searching topic today, very tricky area, very technical area, because it takes quite a lot of time for the immigration judges to make a decision as to refuse sole responsibilities. In some cases, they have gone clearly to refuse them, but a stronger argument ought to be put forward to them in order to help them withhold that decision to refuse. But how can you put forth that powerful argument to stop the immigration judge from making a decision to refuse your words, your children, your sons, your daughters, from coming to join you when you are clearly exercising the rights of a parent over the children, or in this case maybe as well, the son? It is important for you to understand that it is important to seek proper legal advice, deal with it, get some advice, and when we deal with and take instructions from you, we'll be able to handle this matter properly. I thought we have a call. Is that call coming in now, Lucy? Is Lucy online?
Hello.
Hello, Lucy. Hi, this is Law Simplified with Justice.
Yes, hi. My name is Lucia. I just want to ask a question.
Yes, please go straight to it.
Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the immigration rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
We'll bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.